On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, who joins us this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
And let's get right to it. A lot to talk about. One of the first things is a case out of Texas, and this goes back to, as people know, the government has the right to take your property from you if it wants it for public use. But, as is the case under the Fifth Amendment, the government that is, must pay you for it as well. And this is kind of where we go to this case in Texas.
Yeah, this is a really important case for agriculture. It's going to have some implications. This is presently before the U.S. Supreme Court, and they're going to hear arguments on this in January. It's set for January 16 to hear arguments. So we're going to get a decision, I'm anticipating, this term, so by the end of June 2024. And what this involves is a Century Farm down in South Texas. The same family has farmed this land for a century, so it goes back generations in this family. And there never was a problem with flooding until the state came in and renovated a highway and changed the surface water drainage. And in essence, that renovation turned the highway into a dam. And when tropical storms occurred, this is down in South Texas, the water no longer drained into the Gulf of Mexico, and instead the farm was left flooded for days. And their crops were lost, their cattle were killed. In essence, the farm had been turned into a retention pond. And so they sued the state to get paid for taking the farm. I said, well, your road project just ruined our entire farm. You need to pay for it. You, in essence, have taken it. And they didn't win in the state court. It gets transferred over to the federal court. And then the appellate court at the federal level dismissed it, saying that, well, you can't sue under the Fifth Amendment. Only state officials can. Now, that seems kind of bizarre to me. I've not seen that argument raised before, never seen it raised successfully. So I think that's incorrect, and the Supreme Court has taken this case because the Fifth Amendment does give you a remedy when the government takes your property. And as you mentioned, under the Fifth Amendment, you get paid for it. That's your remedy. And so it's not like an individual landowner, a farmer, a rancher doesn't have a remedy in these situations. It can't sue. You do, and that is the government has to pay for what it's taken. So we shall see. The outcome is going to be an important one for agriculture.
Because, pardon the term, but this could, depending on the decision, could open up a whole can of worms, so to speak.
Yeah, I don't think it ultimately will. I think this one's going to be pretty easy for the U.S. Supreme Court, but we never know. I look at the facts on this, and I've read the briefs on it, and it appears to be pretty compelling on the facts that, yes, there was a taking, and yes, the issue is what it's going to boil down to is what the government's going to have to pay. But I think it's pretty clear that there was a taking, and I think that's probably why the U.S. Supreme Court took this case.
All right, next up, talking about the tax treatment of income from farm-related assets, but let's break this down a little further. Let's go with breeding fees. So if you report income from breeding fees and then later issue a refund and still report the breeding fees as income in the year received and then make a deduction when the refund is made as well. Tell us how that might be affected.
Yeah, well, that's the rule. And if you do charge breeding fees, and some farmers do this, it's a service that they provide, and so you have to report the income from your breeding fees in the year that you receive it. And I'm going to assume, for purposes of conversation here, that we're talking about cash method farmers using the calendar year. So if I've charged breeding fees for a breeding service this year and I get paid, then I'm going to report that in the income in 2023. Now, if I later have to issue a refund, which sometimes occurs in these situations because it wasn't successful, and I issue a refund, I issue the refund in 2024, still go ahead and report the breeding fee income in 2023 and then deduct it when you make the refund in 2024. That's a question I get several times a year on what happens when I have a different tax year from the year in which I charged for the fee and got paid from the year when I refunded it. Well, you still report the income, and then the next year you take it as a deduction if you had to refund the amount.
Now, the next part of that with regards to tax treatment of income from farm-related assets involves soil, sod, or other minerals.
Yeah, and sometimes we see this, Greg, particularly if you have, it kind of relates back to the first case, if we have a state that is doing a highway project and they need to build a berm up, or they want to dig some land, some of your soil out to build a road base up or build a bridge up. And you'll see that as you're driving along, you'll see these pond areas, particularly near an overpass. Well, that's where the state or the federal government has come in and they bought some of that soil, that topsoil, and then they just didn't fill it back in. It creates a pond there. Well, you get paid for those things as a farmer. So this is another one of these unique areas. What do I do with this stuff? And what's the character of this gain? Well, we report the sale of soil, sod, and other minerals if we're doing it on a regular basis as ordinary income. Now, most farmers are not going to fall into that category because that's not what they're in the business of doing. And there's a different tax treatment for that. I'll get to that in a second. But for mineral deposits, if I sell a mineral deposit, then the disposition could be held to be a sale reported as capital gain. But that's probably not going to be the case in most situations because a lease is likely involved. So you need to sort through whether it's a sale or a lease. Now, if I sell topsoil, and we call this borrowment, I'm selling borrow. It's a borrow area. If I can still retain the ability to farm that land, that's different than if I sold the soil and now I can't farm it. I didn't retain any economic interest. So that has a different tax characterization to it than if I can still retain the surface. And in other words, we're going to have ordinary income or capital gain, depending on whether I did retain an economic interest and did I retain the ability to farm the ground. So these are the fact-based issues. If you have this unique situation, make sure you go over this with your tax preparer as they're working on your return for this coming year so that you categorize things correctly.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest this morning, talking about several issues as well. Roger, as we move forward, if you purchase livestock, which many of our listeners have as well, but obviously taxes have to be play into this, and there are certain tax strategies for purchased livestock.
Yeah, that's right. And one of the things that for buyers of livestock to think about, if they're buying livestock that are to be used for draft, dairy, or breeding purposes, is whether they should depreciate those or include them in inventory. Now, the answer to that one really depends, and it's going to depend on your overall tax situation. But purchased livestock that you hold primarily for sale have to be included in inventory. But livestock that you buy or raise for draft, breeding, or dairy purposes, you can depreciate those. So I often get the question from those types of individuals, well, what's my best tax strategy? Should I include them in inventory or depreciate them? Because you do have a choice in this situation. Well, the answer depends. Depreciation can be beneficial for several reasons. You get an ordinary deduction that reduces your net and your self-employment income, and any depreciation recapture is not going to be subject to self-employment tax. If you have a sole proprietor farming operation, and if you're a partner in a partnership, plus the amount of the gain that exceeds your original cost can qualify to be taxed at capital gain rates, and that's probably going to be lower than your ordinary income rate. So the question is whether that's a better tax result than capitalizing the livestock and holding them in inventory. Well, that turns on whether a current deduction for depreciation for you is going to outweigh later capital gain treatment on sale. And I would say for high volume sales that generate significant income, then an inventory method might be better. So that's kind of the answer to it. And really, there are a lot of questions involved in answering that. And this is another one of those where you need to sit down with your tax return preparer and go through what your options are and how it works best in your particular situation.
Roger, another issue that we have discussed or brought up, depending on the situation, of course, is looking at fences. And you pose the question, if your fence meets the state law requirements for a legal fence, is that enough to shield you from liability if your animals got out and caused damage? And you say to that?
Maybe not. You can't just hide behind the statute and say, well, I have a legal fence, and your neighbor says, well, yeah, that's fine, but your animals are still getting out and they're eating my crops or causing damage on my property. Or, heaven forbid, the animal got out and got hit on the road and somebody got injured pretty badly. And you can't just say, well, I have a legal fence. Well, no, the question in Kansas is really whether you have a legal and sufficient fence. And there's a lot of case law on this in Kansas. There's a primary case back in the 1960s that we look to that's still good law today that points out that not having a legal fence is negligence. Of course, and we know that. If you don't have a legal fence, you are negligent. So having a legal fence, that establishes the minimum standard, but it's not necessarily a sufficient fence for livestock. The issue often comes up, Greg, in this situation with animals other than cattle. Everybody knows the standard rules for barbed wire fences with respect to cattle. But we get sheep and goats and other types of livestock where, well, yeah, I've got a fence, but that fence may not be sufficient for the livestock that it is supposed to restrain. So the situation is going to be based on the facts. But the point is, if your fence meets the requirements to be a legal fence, that's just the first step of the analysis. It still has to be a sufficient fence to keep your animals in if you're in a fence-in jurisdiction such as Kansas. So my advice here is don't cause issues with your neighbor by insisting that your fence is a legal fence because it meets the minimum statutory requirements. That's literally the least you can do. Make sure that you have a sufficient fence.
Next up, we move down into the state of Oklahoma. And as a matter of fact, this decision was handed down late this year, and it involved the ordering of the removal of an entire commercial wind energy development in the state of Oklahoma, and they have set a trial for damages.
Yeah, this just came out last Wednesday, Greg, and this is huge. And we're near the end stage of all of this. We're down to just counting up the dollars now. But this is the first time I've ever seen a court order the removal of an entire wind farm. And what this was 84 towers spread across 8,400 acres of leased land, surface rights and underground lines and overhead transmission lines and meteorological towers and access roads. All of that has to be torn out. And this is going to be, you can imagine the cost on this, a tremendous amount of cost. And this litigation has been going on for over 10 years. And most recently, back in 2017, there was a lower court decision that concluded that constructing of the development down there constituted mining and therefore required a mining lease from a tribal mineral council. This is on tribal ground, which the developers failed to acquire. And then it went to the 10th Circuit. And in 2017, the 10th Circuit said the wind energy company's extraction, sorting, crushing, and use of minerals as part of its excavation work constituted mineral development, which required a federally approved lease. And the company never got a federally approved lease. And so we get the next decision on this. The 10th Circuit kicks it back to the district court, the trial court down in Oklahoma, for a decision consistent with what the 10th Circuit ordered or ruled. And the trial court last week said, yeah, you got to remove everything. And the court weighed several factors, but ultimately concluded that the public interest in private companies abiding by the law and respecting government sovereignty and the decision of the courts was paramount. And this was a judge sitting by designation who is a judge for the Court of International Trade. So this is a big time decision, and now they're going to have a trial on damages. And so it's the first time I've ever seen an entire wind farm ordered to be removed because they failed to get the appropriate documentation.
And as we hit the end of the year, Roger, a lot of farmers, they often want to eliminate income taxes every year. But there may be, as you state, a better strategy over the long run, and that would be to optimize the amount paid each year.
Yeah, and I know this is a hard one for farmers to understand because by definition, you can tell when a child is going to grow up to be a farmer. They're born, I'm convinced, with a chip in their brain that says, thou shalt not pay income tax and thou shalt never pay self-employment tax. So this is going to be a tough sell for listeners. But really, you want to think about optimizing tax over the long run rather than trying to eliminate it. So let me give you a couple of examples here. As a farmer, of course, farmers can file and pay taxes by March 1. Or you can simply pay one estimated tax payment on January 15 and then pay the balance on April 15. But to do that, the amount you have to pay by January 15 is the lesser of 100% of last year's tax liability or 2/3 of this year's tax liability, what you estimate that's going to be. Now, here's the catch. With higher interest rates, if your tax bill is going to be substantial, the saving on deferred tax for 6 weeks can add up. And what I mean by deferred tax is deferring payment from March 1 to April 15. And so that can relate to a lot of money. And so do the math to figure out what the best approach is for you. Other things that you can think about, farmers can do things after the end of the year that still affects the 23 return. You can, for example, decide to not defer grain contract income by reporting that income in 2023. If you have crop insurance, only the portion of crop insurance payments that you receive in 23 that relate to yield loss will be deferrable into 2024. The price loss portion is not deferrable. For 24, if you have children under age 18 that work on your farm, if you pay them wages, that won't trigger payroll tax. If they're older, pay them in grain to get the same result. And also consider gifts of grain to children to drop your tax liability and not create one for the child. And that one can still be done this week.
All right, Roger, we're out of time. But first, as always, if people want to get more information or read up on everything as well, they can go to your blog.
They can go to my blog, and they can find that in several places. They can find it on my website or on also over on Ag Manager K-State on RFD TV site also.
All right, sounds good. Well, coming up, of course, we're going to talk about what you consider some of the top cases in 2023. Always look forward to that, and we'll talk to you here in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he has been our guest on the Ag Issues program here on 580 WIBW.